as ministers in the temple of justice.
For anyone on the bench of the Nigerian judiciary, this chamber is the ultimate.
Let us all strive to maintain the independence of the judiciary so as to ensure the rule of law.
And the fact that the ministry is responsible for prosecution of cases makes the ministry very visible naturally.
Of the Federal Republic of
And the Nigerian Bar Association.
If it is to buy time, you know who is buying time.
Becoming the first woman in the country to discharge the function. To me, Allah wished it that way.
Welcome to the program, The Scale of Justice.
Tune in every Monday at 2:05 p.m. and the repeat broadcast comes up every Wednesday at 6:30 a.m. on the network service of the NTA. Keep the dates with us.
Hello, this is The Scale of Justice, that program that x-rays happenings in the Nigerian justice sector. I am yours, Femi Okewo, with the pleasure of having you on this program. Every judgment of a court, particularly the Supreme Court, helps to develop our laws. So now we know that no law is really law until it is tested. Section 396, subsection 7 of the Administration of Criminal Justice Act was introduced into the Act to resolve a major defect in Nigeria's criminal trial processes, which is the long duration of our criminal trials and their lack of conclusion, particularly when judges who started the trials are promoted. But alas, the Supreme Court has shut down that section in the appeal of Uzor on his corruption trial. Let's share with you what that section says. And now, Olabode Arewa tells us what the Supreme Court judgment was like.
In her judgment, the presiding justice, Justice Amina Adamuawge, said the President's Court of Appeal erred in law when she granted leave for Justice Mohammed Idris to return to the Federal High Court in Lagos and conclude Uzor Kalu'S corruption trial. The Apex Court subsequently directed the Chief Judge, Federal High Court, to reassign the case to another judge for a fresh trial. The appeal was filed by Ude Jones Ideogu, a former finance director, Abia State Government House, challenging his conviction and imprisonment, along with ex-governor Uzor Kalu. While Uzor Kalu was sentenced to 12 years imprisonment, Ude Jones Ideogu was sentenced to 10 years imprisonment.
And the Supreme Court just said today that no justice of the Court of Appeal is competent to return to the Federal High Court to conclude any matter. That we don't have a hybrid judge, one as a Federal High Court judge and the other side as a Court of Appeal justice. And the Supreme Court specifically struck down the provisions of Section 396, subsection 7 of the Administration of Criminal Justice Act, and held that that section is inconsistent with the provisions of the Constitution, that is Section 253 of the 1999 Constitution. What the Supreme Court did today was to affirm its earlier decision both in 1979 in Ogbunyinya Nokudo and in 209 in our line limited. And with this decision, the judgment of the Federal High Court presided by a justice of the Court of Appeal has been declared null and void.
My client is one of the beneficiaries of this judgment. And what it means is that there has never been any valid proceedings against them in the criminal trial. Therefore, they are not guilty of any offense, and they have never been tried for any offense. And as such, they are going to be released. That is the implication of this judgment. So the procedure followed by the Court of Appeal, giving a fiat, the President of the Court of Appeal giving a fiat to a judge of the Court of Appeal or Justice of the Court of Appeal to go and conclude the matter at the Federal High Court. That procedure was declared a nullity by the Supreme Court. The trial will have to commence de novo if the prosecutor or the prosecution is still interested in pursuing the case.
Well, it is the Supreme Court. There is nothing we can say. The Supreme Court is final. Whatever the decision of the Supreme Court is, everyone has to abide by it. The court has said that Section 396, sub 7 of the Administration of Criminal Justice Act is unconstitutional. Well, we have no option than to abide by the decision of the Supreme Court.
So why would a law that had even been flaunted at various times as an instrument to be used to fight corruption now be declared unconstitutional? The scale spoke to Mr. Joseph Daudu, Senior Advocate of Nigeria, a renowned defense attorney. What came to your mind when you heard of the Supreme Court's judgment in Uzor Kalu'S case?
Well, I just felt that justice has been served, that the right thing has been done. That's what came to my mind.
Everybody, all of a sudden, would think this is the right thing. But years ago, 5 years, 4 years since the Administration of Criminal Justice Act came to be, everybody thought that that provision 396 was good for the fight against corruption.
Well, you see, you have been part of a lot of seminars that we conducted to enlighten people on the Administration of Criminal Justice Act. One of the gray areas is the provision of Section 396, subsection 7. We raised the red flags at that time, saying that that provision will be declared as unconstitutional. And the reason is clear. It will be declared, and it has been declared as unconstitutional, because the person sitting to hear his parted matter has lost, the operative word is lost, his jurisdiction to sit as a federal high court judge or a high court judge. Now, the pretentiousness in the Administration of Criminal Justice Act is that it seeks to do what the Constitution ought to do. It is the Constitution that sets out the jurisdiction, the powers, and the composition of both courts. That is the Court of Appeal and the Federal High Court. It also, by Section 246, gives it original jurisdiction to hear presidential election petition and to deal with other matters relating to election. That is the only jurisdiction the Justice of the Court of Appeal can exercise. It does not include that jurisdiction to return to its old court to hear and determine part-hard matters. So effectively, when a judge is elevated to the Court of Appeal, two things happen. He loses the jurisdiction to sit as a justice or a judge of the Federal High Court or High Court. And when he has now, whether sworn in or not, as soon as his appointment is gazetted or is even announced, he loses that jurisdiction to sit as a High Court judge. He then goes to the Court of Appeal and starts sitting. Now there is this ACJA provision 3967 that says that he can return for the purposes of completing part-hard matters. At that point in time, he is not a Federal High Court judge. He has been sworn in. And this is the grand norm, the Constitution speaking. A small Lilliputian legislation like the Administration of Criminal Justice Act cannot go in collision with the Constitution. It's simple as ABC. But those who thought that they could override existing precedents of courts felt that if they inserted that section, that it would solve the problem. We said it would not, and that very soon it will cause a crisis in the system. Now, the president of the Court of Appeal that gave fiat to a justice of the Court of Appeal has no such powers, whether in the Constitution, in the Court of Appeal Act, or even the Federal High Court Act.
Sometime in February this year, it was even celebrated that so far 50 justices at various divisions of the Court of Appeal had been given fiat to go back and conclude their cases.
We laughed. Those of us who knew better knew that if you had a Supreme Court that was following its precedent and bold enough to disallow such shenanigans, that they will set aside all those cases. It's either you don't promote judges hearing sensitive cases and you allow them finish before you elevate them, or when they go, you start afresh. You can't eat your cake and have it. You can't. So the president of the Court of Appeal had no powers to even issue the fiat. And that had been quashed. It's null and void.
Now, all the cases that these justices have gone to conclude and have passed judgment over the last 5 years since the Administration of Criminal Justice Act came into existence, will they have to be quashed one after the other, or they fall like a pack of cards along with this judgment?
No, they have to. The judgment of Uzor, Kalu, is what you call a judgment in personam. There had been a time in the Supreme Court, 2 people were convicted of murder. One appealed, the other did not appeal. For one reason or the other, they said the notice of appeal sometime in 1982. Fortunately, upon appeal, the conviction was quashed, and he was discharged and acquitted and asked to go. At that time, the one that didn't appeal now sought to appeal. There was no room for extension of time to appeal at that time. And the Supreme Court justices rightly said, we have no such powers to extend time. Now, whether he was eventually executed or not, I don't know. But I remember the Supreme Court telling them to go and look for pardon, citing this other case as an example. So they do not fall like a pack of cards. It's a judgment that inures only to those who are the appellants in that case.
So our laws continue to evolve and develop, just as our court system seems to be developing now in the face of the new circumstances created by the coronavirus pandemic. You have heard it said oftentimes that justice delayed is justice denied. So justice should not be made to wait just because there is a general lockdown. In order for our courts to still run effectively, technology is now being brought on board. In addition to the National Judicial Council's drive in this regard, a number of courts have started adopting the virtual sitting. The Borno State High Court is one.
This is the first online court sitting in Nigeria by the Borno State High Court number 13, Maiduguri, featuring virtual courtroom. The significance of adopting virtual courtroom is not unconnected to the preventive measures against coronavirus pandemic, which led to an extension of court's closure by another 2 weeks. Borno State Judiciary had directed continuation of trial in criminal cases up to judgment to ensure justice is not denied in the face of nationwide lockdown and calls for prison decongestion.
Our aim has never been just because of COVID. Even under normal circumstances, the old normal, still there is no need to delay cases because of just simply somebody appearing in the court to open his mouth to talk. That he can do from anywhere in the world.
The State Chief Judge, while monitoring the court sitting online, says more cases will follow suit, as this one involving the state versus Ali Muhammad found the accused not guilty of the offense of culpable murder, hence was discharged and acquitted by Justice Fadau Umaru presiding.
Now that COVID has brought that reality, we are hopeful that these changes will now come fast and we will show you more that we can do. We can end up making it a rule even that we will not allow, just for the sake of coming to talk, we will not even allow anybody to come. You have to do it online.
The online or virtual court sitting is made possible using a software application for meetings or teleconferencing, redesigned to fit a court proceeding. The Borno State Judiciary says the COVID-19 pandemic has not taken them by surprise, as they are fully equipped for the dispensation of justice without delay.
And then the FCT High Court too has started its own virtual sitting.
Court proceedings have been few during this period of COVID-19 due to fears for the health and safety of lawyers, litigants and judges. The FCTI Court has taken a proactive step to ensure the wheels of justice continue to turn when it adopted the remote method of conducting court hearings using computer-based applications. Justice Peter Afem of the FCTI Court 2, as well as Justice Hussein Baba Yusuf of the FCTI Court 3, sat on pending criminal and civil cases before them. The Chief Judge of the FCTI Court, Justice Ishak Bello, said the virtual court sitting method will be fine-tuned.
What you are witnessing today here in the FCT is as a result of my conscientious decision in collaboration with my brother judges to take up the requisite steps towards enthroning the system of remote sitting in this court in order to address certain compelling and time-bound matters. Not only to attend to those cases, but also to insulate the judges from exposure, not only judges, lawyers, parties, members of the press, from exposure to possible affliction by this deadly virus, the coronavirus. And along the way, to marshal the practice of digitalizing all case files and by such enthronement of the relevant technology to make it possible for speedy generation of record of proceedings. You would notice that as the judges sitting in court now, conducting proceedings, already recording is taking place. So we are going to eliminate the snail speed in generating records in case of an appeal, or even when people are desirous of having, for their own personal records, decisions of the court in respect of their disputes, which will be resolved. So it's not just, what you are seeing today is not just meant to cater for the COVID-19 period. It goes beyond. It is a practice that has come to stay. It will reduce cost of litigation. It will reduce unnecessary stresses on the part of parties coming from far apart to come all the way to Abuja for litigation. They can stay within their respective offices or within their respective homes, so long as they can link up to the platform, so be it.
Section 84 of the Evidence Act of 2011 provides that in any judicial proceedings, a statement contained in a document which is produced by a computer is admissible as evidence of any facts stated in it, of which direct oral evidence would also be admissible once it is shown that the conditions in this section of the law are satisfied. This provision of the law forms the basis for the current advocacy for the adoption of the use of technology-based applications to conduct court hearings in Nigeria. The advocates observe that the process of using computer technology to conduct court hearings is the current practice in many other court jurisdictions, and it has inherent benefits for the Nigerian legal system, pointing at the closure of the courts during the coronavirus pandemic in the country.
We must be up and doing in terms of virtual sitting. We said it time without number in the past that courts should fix cases according to time. You fix my case maybe 9 o'clock, another case maybe 11, another 12, another 1. That is what is being done everywhere if it is physical hearing. Now with this challenge of COVID-19, I think we must go back to the drawing board and see how we can rapidly catch up with what is the practice, what is the tradition, what is the norm in other established jurisdictions.
This COVID-19 challenge can be converted to an opportunity to make our country great. And how can we do that? One of the ways we can do that, particularly in regards to the justice sector, which is the focus of our discussion today, is we need to begin to activate remote hearings, or what we call virtual hearings of court of proceedings. Happily, the NJC took a step in the right direction by convening a meeting of the NJC, which was online. The meeting took place virtually, in the sense that the chief judges and other members of the NJC who don't reside in Abuja were able to connect via electronic platform. And they had a successful meeting and made a lot of beneficial recommendations, including appointment of judges, those who have been disciplined, all of these things, all these decisions were taken at that virtual meeting. So that is the way to go. If everything is done electronically, we'll be more conscious of time, because you can't be on the internet forever, because everybody needs space. Everybody needs space, to be able to make their case. And having filed our processes, having written our arguments down, so we need very little time to elaborate.
The Chief Judge of the Federal High Court, Justice Johnson, says the use of virtual or remote methods to conduct court hearings would have to be uniformly adopted by all the Federal High Courts for efficient justice delivery in the country.
And that's the much we have on the scale today. We have updated you on the happenings in the justice sector and the efforts to continually develop our laws. Thank you for being part of the program today, and we shall be on top of the various other issues cropping up in the justice sector of Nigeria. We'll see you again.